Welcome back and happy Friday. I forgot to mention that off the top. The 22nd Amendment to the Constitution limits American presidents, well, of course, it's the American Constitution, to 2 terms in office. Hasn't stopped President Trump and those who support him, however, from suggesting a 3rd term.
Should I run again? You tell me. There's your controversy right there. There's your controversy.
We want Trump in 28. That's what they can't stand. A man like Trump comes along only once or twice in a country's history, right? We want Trump.
I want to bring in Josh Chaffetz. He is a professor of law at Georgetown Law School. Josh, it's great to have you here. Thanks. Very briefly, give me your commentary legally on the 22nd Amendment and all this chatter, which the White House likes to describe as just sort of a joke about a 3rd Trump term.
Well, it is a joke, constitutionally speaking. I mean, the text of the 22nd Amendment is incredibly clear that presidents can only run for 2 terms in office.
Welcome, guys. Adam is here, so this is happening right now headlines. Claiming Trump's presidency is ending right now are false. No active impeachment or removal is imminent. The 22nd Amendment sets a future term limit, but the underlying constitutional analysis is still worth covering accurately, even if the dramatic framing is wildly overstated. Here is the documented picture with appropriate calibration. Article 2, Section 4 of the Constitution states that a president shall be removed from office upon impeachment and conviction for treason, bribery, or other high crimes and misdemeanors. That is the constitutional text, a documented primary source fact. Some members of Congress have introduced impeachment resolutions citing that constitutional language and accusing Trump of abuse of power, obstruction of congressional investigations, and violations of the First Amendment, documented through academic and policy analysis sources.
This weekend, President Donald Trump made headlines for floating the idea of running for a possible 3rd term, despite not being constitutionally allowed to do so. He told reporters on Air Force One Sunday there's a lot of interest from his supporters.
I have had more people say, please run again. They said, we have a long way to go before we even think about that.
During a call with NBC News on Sunday, he said that there are, quote, methods he could use and that he is, quote, not joking about this. So what are the constitutional limits around presidential terms and when were they introduced? President Franklin Delano Roosevelt is the only person to have served more than 2 terms in American history. Before this, presidents did not run for more than 2 terms because of a precedent set by George Washington.
The 22nd Amendment, also a documented primary source constitutional text, limits any person to being elected president no more than twice, which constrains Trump's ability to seek a 3rd term regardless of any other outcome. Academic scholars, including a Stanford historian and contributors to a German constitutional law publication, have analyzed what they characterize as constitutional failure. Not a single crisis, but a cumulative pattern of executive aggrandizement combined with insufficient congressional and judicial checking. A comparative constitutional analysis documented that Trump lacks the public support and institutional tools that some authoritarian leaders have used to circumvent term limits through referendums or captured courts. Those are the documented elements: constitutional text, academic analysis, some congressional impeachment activity, and comparative constitutional scholarship.
President Donald Trump on Monday declined to dismiss speculation that he would seek a 3rd term, saying he hadn't considered whether he would go to court to contest the U.S. Constitution's 2-term limit for presidents.
I would love to do it. I have my best numbers ever. It's very terrible. I have my best numbers. If you read it, am I not ruling it out? I mean, you'll have to tell me. All I can tell you is that we have a great group of people, which they don't.
But what barriers stand in the way of another term? Scott Anderson is from the Brookings Institution.
So the conventional wisdom, and I think it's the right one, is that he cannot. The 22nd Amendment, adopted in 1951, says no one may be elected to the presidency more than 2 times.
The amendment was ratified in 1951 after President Franklin D. Roosevelt broke with a self-imposed 2-term limit set by presidents since George Washington.
Now, before we dive deep, let me also tell you how U.S. President Donald Trump has been facing political pressure in his own country, as the Democrats have escalated efforts to question his fitness for office. more than 85 House and Senate Democrats are now calling for Trump to be either impeached or removed through the 25th Amendment. This move comes after Trump's recent remarks, including "a whole civilization will die tonight" in a clear reference to Iran. Lawmakers have now introduced a striking proposal tied to the 25th Amendment, aiming to create a formal mechanism to assess whether Donald Trump can still serve. Under the proposal, congressional leaders would each appoint 2 members. It would include 4 former high-ranking executive branch officials. What is genuinely significant about the constitutional analysis this brief covers when properly calibrated is the documented academic synthesis of how the various constitutional accountability mechanisms we have been documenting throughout this series fit together as a framework.
Congressional Democrats are now calling for President Trump's removal from office following his extreme threats against Iran. They say the ceasefire isn't enough and are calling for Congress to rein in the Trump administration.
Well, a 2-week ceasefire is insufficient. We need a permanent end to Donald Trump's reckless war of choice. House Democrats have demanded that Speaker Mike Johnson immediately reconvene the House back into session so we can move a war powers.
Ladies and gentlemen.
Yesterday, more than 70 lawmakers in separate posts on social media suggested the president's cabinet must invoke the 25th Amendment and admit he's unfit for office. Congress should pass impeachment articles and vote to convict him, or both. During his first term, he was impeached twice and acquitted.
We've covered the Supreme Court tariff rulings, the nationwide injunction curtailment, the removal power cases, the district court reinstatements, the multi-state lawsuits, the Kennedy Center name removal, and dozens of individual judicial accountability actions. The Stanford Constitutional Failure Analysis and the Comparative Constitutional Framework are the academic perspectives that place all of those individual accountability threads into the broader documented constitutional pattern. Whether that pattern constitutes constitutional failure, as the Stanford analysis argues, or constitutional testing whose outcome is still unresolved, is the analytical question the academic sources are addressing. The constitutional text, Article 2, Section 4, and the 22nd Amendment is the documented foundation against which both the executive overreach and the checking mechanisms are measured. All right, so let us go through the specific documented elements carefully, because the Article 2, Section 4 constitutional text, the 22nd Amendment term limit constraint, the impeachment resolution citing Article 2 activity, the constitutional failure academic framework, and the counter-constitution analysis each deserve their own treatment with appropriate sourcing distinctions maintained throughout. Let us start with Article 2, Section 4 as a documented constitutional text, because grounding the analysis in the specific constitutional language is the accountability foundation that makes everything else in this brief most meaningful. Article 2, Section 4 states that the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Those are the specific constitutional words, a documented primary source from the text of the Constitution itself. The high crimes and misdemeanor standard is the specific phrase that constitutional scholars and historians have debated most extensively because it is the broadest and most discretionary of the removal standard's 3 categories. Treason and bribery are defined legal concepts with specific elements. High crimes and misdemeanors is a phrase whose content the framers left undefined, drawing on an English parliamentary accountability tradition in which the phrase describes serious abuses of public trust, rather than requiring specific criminal law violations. The significance of Article 2, Section 4 in the current second-term context is that it is the specific constitutional mechanism whose activation through impeachment and conviction would produce the president-removed outcome. It is the specific provision that Democratic impeachment efforts have been invoking throughout the second term. We covered the 70-plus Democrats filing 25th Amendment calls in the resignation call script, and we have documented the House control dynamics and the discharge petition strategy in multiple scripts. Impeachment under Article 2. Section 4 requires a House majority to impeach, 218 votes, followed by a 2/3 Senate majority to convict and remove, 67 votes. current congressional composition, a thin Republican House majority and a Republican Senate majority, makes those vote thresholds specific documented barriers to the mechanism's activation regardless of the strength of the underlying legal theory. The impeachment resolutions citing Article 2, Section 4 are documented congressional activity. Their activation through the full constitutional process requires vote thresholds that the current congressional composition does not provide. The 22nd Amendment is the constitutional constraint whose documented significance is different from Article 2, Section 4 because it operates independently of congressional will and without requiring any specific vote. The 22nd Amendment states that no person shall be elected to the office of the president more than twice. That text is unambiguous. It limits the number of times any person can be elected president to 2. Which means Trump, having been elected previously and again, cannot legally be elected president again, regardless of any other outcome. The amendment was ratified in the 1950s specifically in response to Franklin Roosevelt's 4 terms, establishing the constitutional outer boundary on presidential tenure that has governed every president since. Trump has made documented public statements musing about serving a 3rd term or beyond, which the comparative constitutional analysis documented as lacking any realistic path given the United States amendment process requirements and Trump's current public support levels. The comparative constitutional analysis is the most specifically grounded of the academic sources in this brief because it compares Trump's situation with documented cases from other countries where leaders have circumvented or attempted to circumvent term limits. The analysis documents that Latin American leaders who successfully extended their tenure beyond constitutional term limits typically did so through one of 2 mechanisms: getting captured courts to rule term limits unconstitutional or holding referendums to amend the Constitution with supermajority public support. The analysis then documents that Trump lacks both mechanisms. The current Supreme Court has not indicated any inclination to rule the 22nd Amendment unconstitutional, and Trump's documented approval ratings nationally do not suggest the supermajority public support that a constitutional amendment through referendum would require. That specific comparative analysis grounds the 22nd Amendment constraint in the documented comparative institutional and political context rather than treating it as merely theoretical. The Stanford historian's constitutional failure analysis is the most intellectually significant of the academic sources, and it deserves documentation as a specific scholarly perspective rather than as a news report. The constitutional failure framework distinguishes between a constitutional crisis, a specific conflict between competing constitutional claims, and constitutional failure, the cumulative erosion of constitutional guardrails through repeated testing combined with insufficient institutional response. The framework is analytical rather than partisan. It does not depend on a finding that Trump acted with malicious intent, but rather on the documented cumulative pattern of executive action exceeding established constitutional limits, alongside congressional and judicial responses that have been inconsistent and incomplete. We have been documenting throughout this series exactly the pattern the constitutional failure framework describes. Specific executive actions exceeding constitutional authority, courts blocking some while staying others, Congress voting on war powers while not activating impeachment, and the aggregate producing a documented record of executive power testing whose cumulative constitutional consequence is the question the Stanford analysis addresses. The German constitutional law publication's Counter-Constitution analysis adds an international constitutional law perspective, whose international perspective on American constitutional developments is a different analytical lens than domestic American constitutional commentary. The Counter-Constitution framework describes how a determined president and allied lawyers can use the tools of constitutional law, emergency powers, executive orders, selective enforcement, to achieve outcomes that erode the constitutional order while formally remaining within legal tools. We have documented throughout this series the specific instances that the counter-constitution framework is describing: the emergency tariff authority deployed beyond its statutory bounds, the Alien Enemies Act invasion theory rejected by a Trump-appointed judge as beyond the statute's recognition, the independent agency removal authority tested against statutory protection statutes, the Supreme Court tariff ruling finding that one of those emergency power deployments exceeded constitutional and statutory limits. The counter-constitution framework is the academic synthesis that places those individual documented cases within a broader pattern analysis. The academic paper documenting the pattern of presidential norm violations, including challenging election legitimacy, undermining Congress's role, and pressuring the justice system, is the academic documentation of the behavioral pattern whose individual entries we have covered across dozens of scripts throughout this series. From the attacks on the Supreme Court, to the traitor characterizations, to officials being fired for insufficient political prosecutions. The cumulative behavioral catalog that the academic analysis documents is the specific pattern that the Stanford constitutional failure and counter-constitution frameworks are analyzing in constitutional accountability terms. Okay, so let me be really clear about what the documented constitutional text, the academic analysis, and the current congressional and judicial accountability picture mean with the calibrations from the hook maintained throughout. The first thing to understand is why the Article 2, Section 4 and 22nd Amendment framework matters as an accountability synthesis. Even though neither mechanism is actively removing Trump from office right now, the accountability significance of the constitutional text is that it establishes the documented standards against which executive conduct is measured, both for the impeachment mechanism and for the comparative constitutional analysis. Every judicial ruling that finds a Trump executive action exceeded constitutional or statutory authority is applying the same constitutional framework that Article 2, Section 4 invokes for removal purposes. The principle that presidential power has documented constitutional limits whose enforcement is the job of courts and Congress. The courts have been enforcing specific documented limits throughout the second term. The tariff ruling, the Kennedy Center ruling, the Alien Enemies Act ruling, and the independent board reinstatements. The constitutional failure framework's question is whether those specific documented judicial enforcements add up to sufficient checking of executive power, or whether the incomplete and inconsistent enforcement pattern represents the cumulative failure the Stanford analysis identifies. The second layer worth sitting with is the 22nd Amendment's specific significance as the outer constitutional boundary that operates independently of political will. We have covered the statement in which Trump publicly acknowledged that congressional composition determines his impeachment exposure. The 22nd Amendment's outer boundary operates differently. It is not contingent on congressional composition or on courts' willingness to enforce it. It is the constitutional text that prevents a third-term election regardless of political conditions. Whether Trump's third-term musings represent genuine planning, wishful thinking, or deliberate provocation of constitutional norms is a question the available documentation does not definitively resolve. What is documented is the 22nd Amendment text, the comparative analysis establishing that Trump lacks the mechanisms to circumvent it, and the specific documented public statements about extended tenure. The third layer is the constitutional failure versus constitutional crisis distinction, and why it is the most analytically significant element of the academic sources this brief covers. A constitutional crisis implies a temporary conflict between competing constitutional claims. A crisis that will be resolved one way or the other through constitutional processes. Constitutional failure implies something more permanent, the cumulative erosion of the constraints that make constitutional government function through repeated testing, combined with insufficient institutional response. The Stanford analysis argues the current moment is closer to failure than crisis, not because any single event has broken the constitutional order, but because the cumulative pattern of executive aggrandizement and incomplete institutional checking represents a qualitative change in how constitutional limits operate. Whether that analysis is accurate or whether the documented judicial and congressional checking throughout the second term represents constitutional resilience rather than failure is the analytical question that the academic sources are engaged with, and that the documented second-term accountability record most directly informs. Now, to give the complete and fair picture, Trump and his supporters have arguments about the constitutional analysis that deserve acknowledgement. They would argue that every president pushes constitutional limits and that the specific limits courts have applied to Trump reflect contestable legal theories rather than clear constitutional violations. They would argue that the constitutional failure framework is an academic perspective whose selective application to Trump ignores the constitutional norm violations of predecessors. They would argue that Trump's third-term musings are rhetorical and that the 22nd Amendment is not at risk. And they would argue that impeachment resolutions with no prospect of passing the Republican House are political theater rather than serious constitutional enforcement. These are real arguments. Presidents do push constitutional limits. Academic frameworks have contested applications. The 22nd Amendment is structurally secure. House Republican majority makes impeachment unlikely. These deserve acknowledgement. But here's what those arguments run into when you apply them to the documented record. The constitutional limits that courts have applied to Trump in the second term, the Supreme Court tariff ruling, the Alien Enemies Act ruling, the independent board reinstatements are documented judicial determinations, not academic characterizations. The constitutional failure framework's documented evidence base is the specific pattern of executive actions that courts have found exceeded authority, not simply a partisan academic opinion. The 22nd Amendment structural security is consistent with Trump's documented public statements musing about a third term, which are either rhetorical or genuine, but in either case are in the documented public record. And the impeachment resolution's practical failure to reach the House floor reflects the thin Republican majority congressional composition, rather than a determination that the underlying conduct does not meet the Article 2 standard. So here is the bottom line on all of this. The presidency ends headline is the calibration that must be stated directly. Trump's presidency has not ended, and no mechanism is currently positioned to end it. What is documented is Article 2, Section 4's constitutional removal standard. The academic sources analyzing whether documented second-term executive conduct meets that standard. The 22nd Amendment's documented outer boundary on presidential tenure, the comparative analysis establishing that Trump lacks the mechanisms some authoritarian leaders have used to circumvent term limits. The Stanford historian's constitutional failure framework analyzing the cumulative executive aggrandizement pattern. And the counter-constitution analysis of how legal tools can be deployed to erode constitutional order. The sourcing is almost entirely academic rather than mainstream news, and I note that sourcing tier throughout. The constitutional analysis is genuine and significant. The headline is not. If you think the documented academic constitutional frameworks and the Article 2 and 22nd Amendment text represent a static accountability picture, think again. The upcoming midterms, whose outcome Trump himself publicly acknowledged determines his impeachment exposure, and the ongoing judicial accountability documentation that we have been building throughout this series are the active accountability mechanisms whose consequences are still unfolding. The Constitution's documented constraints exist. Whether Congress and courts enforce them consistently is a constitutional failure question the Stanford analysis poses. You're going to want to be here as the enforcement record continues to develop. The high crimes and misdemeanor standard deserves specific historical documentation, because understanding what the framers meant by that phrase is the accountability foundation for evaluating whether any specific executive conduct meets the removal standard. The phrase derives from English parliamentary practice, where high crimes and misdemeanors describe serious abuses of public trust by officials, not necessarily crimes in the modern criminal law sense. The framers drew on that English parliamentary tradition when drafting Article 2, Section 4, and the historical record documents that they understood high crimes and misdemeanors to cover serious abuses of official power, betrayal of public trust, and conduct fundamentally incompatible with the duties of office. That documented historical meaning is specifically significant for evaluating whether specific second-term executive conduct, using emergency powers beyond their statutory bounds, deploying the DOJ against political opponents, attempting to circumvent independent agency statutory protections, could meet the removal standard under the text's original intent. The academic analysis this brief covers, the norms paper, and the Stanford Constitutional Failure Framework, is specifically engaging with that high crimes and misdemeanors historical standard when it analyzes whether the documented second-term behavioral pattern crosses the removal threshold. The documented gap between the academic analysis, finding documented conduct that meets the historical standard, and the practical congressional composition barrier to activating the mechanism is the specific constitutional accountability tension the brief is describing most accurately. Academic scholars and some Democratic members of Congress argue that the documented second-term conduct meets the Article 2, Section 4 standard on its merits. The thin Republican House majority means the mechanism cannot be activated regardless of the merits argument strength. That gap between the documented constitutional standard and the documented congressional composition preventing its activation is the most accurate description of the constitutional accountability situation rather than the presidency-ending characterization the headline proposes. The weaponized impeachment counterargument that opponents of the impeachment resolutions invoke is worth specific documentation because it reflects a genuine constitutional concern about the impeachment mechanism's use, rather than simply a defense of specific conduct. The weaponized impeachment criticism argues that using impeachment for politically motivated partisan attacks, rather than for the constitutionally intended purpose of removing officials whose conduct genuinely threatens constitutional government, degrades the mechanism and makes it a standard political tool rather than an extraordinary constitutional remedy. That criticism has documented historical validity. The Clinton impeachment over a sexual affair and the specific framing of each Trump impeachment are all cases where the weaponized impeachment concern has been raised by critics across the political spectrum. The impeachment resolutions citing Article 2, Section 4 and high crimes and misdemeanors in the current second term will be evaluated partly on whether the conduct they cite genuinely meets historical high crimes and misdemeanor standard or whether they represent the weaponized impeachment pattern the counter-argument identifies. That evaluation is the constitutional accountability question the academic frameworks are addressing, and its resolution through the political and judicial processes is the ongoing accountability story rather than a concluded one. The constitutional accountability picture is complex, nuanced, and still developing. The headlines screaming about the presidency ending are false, but the underlying constitutional analysis of executive power limits, term constraints, impeachment standards, and institutional checking mechanisms is genuinely significant and worth understanding. The Constitution provides the tools for accountability. Whether those tools are activated depends on political will, congressional composition, judicial determination, and public pressure. And that's the real story here. Not a presidency that has already ended, but a constitutional system that is being tested and whose ultimate resilience is still being determined. Make sure you're subscribed because this is going to keep developing and changing. This story is far from over.